So, welcome everybody. We are so excited to have you here. My name is Kari Sotner. I'm the president and CEO of Eastern State Penitentiary Historic Site. This is a historic site that is located in Philadelphia. I'm actually at the site right now. It is not an active present penitentiary, but it is a site of the first criminal justice reform in America. And so the work that we do here at Eastern State really looks at how do we understand the justice system as a whole, not just the section around criminal justice, and do that work in a nonprofit, nonpartisan way to really understand our past and ensure that we're looking at how it affects us today. The work that started Eastern State all the way back in 1787 was the work of the Quakers. So we hold true to that Quaker idea that every single person that we come in contact with has human dignity. So the work, what we look at with the justice system is also around the lens of the Constitution, the rule of law, and human dignity. Welcome all of you to Justice 101, and we are so excited to talk about a really interesting, fascinating topic today. We're going to talk about the Bill of Rights. We're going to talk about the trial rights in those Bill of Rights, but we really want to center in around the process. And the two people that I have with me today are not just two of my favorite teachers that I've ever met, and also really great writers and really entertaining human beings. They're the experts in this area. So we're going to dive into pre-colonies and talk about these rights. Where did they come from? How do they center people and the law together? And then what are the impacts that we're seeing through the courts today? So thank you both for being here. I have to say, I think this is the first time I've ever had both of you on one panel. So we will see if we can get through an hour. Let me do real quick introductions of two of my favorite people, and then we'll dive into it. And we are going to save some time at the end for Q&A. So if you have questions, feel free to put them in the chat or the Q&A. And every single cool story, article, or book that we talk about, my team is going to wrap up and do a wrap up after this program and send it back to you. So let's start with David French. So David is an amazing writer. He has been a part of this conversation for so many years. So David's one of the most powerful columnists, in my opinion, in the New York Times, along with Akhil. And his discussions, his articles, his work is around the law, it's around the society, and around the justice system. David's path to journalism has included notable careers in the law. That's his framing and his founding. And he began his education at the Harvard Law School and spent 21 years in legal practice, initially as a commercial litigator, but he ultimately focused on constitutional law, defending key issues like free speech, freedom of religion, and due process. Perfect for this conversation. But if you want to follow David and learn more, a little bit about his background is also that he was a senior writer at the National Review, co-founder of the Dispatch, and a contributor writer for The Atlantic. One of his great books is Divided We Fall, America's Secession Threat and How to Restore Our Nation. So many wonderful things to read. Could everybody please, Audible for the Great Abyss in the webinar, a big round of applause. Thank you, Akhil. And now Akhil, which we might spend the next 20 minutes going through your book list, but we will also send it out. So many good books, Akhil, that I love. So Akhil is the Sterling Professor of Law and Political Science at Yale University, where he teaches constitutional law. He's a graduate of Yale College and Yale Law School, and he joined the faculty there in 1985. He's the only living professor, and I found this fascinating, that has won the university's unofficial Triple Crown of Scholarship. So for scholarship, the Sterling Chair; for teaching, the Devane Medal; and alumni services, the Lamar Award. That's pretty impressive, Akhil. And I think you were my first teacher at the Constitution Center, so you are an amazing teacher. He's also an American Academy of Arts and Sciences and contributes to popular publications like the New York Times, the Washington Post, and the Atlantic. He's been on so many wonderful programs, and his book list is mind-blowing. And I will tell you right now, these are the books you buy and have for life, and they're always right behind you on your shelf and you pull from. So anywhere from the Bill of Rights, 1998, America's Constitution, to his newer trilogy of books, The Words That Made Us. Fantastic. And you just, in the last year, released the second of the trilogy, Born Equal, correct?
Yep.
Fantastic. You have blog posts going on, you have great classes going on. We're going to send all of this information out so you can dive into it. But without further ado, let's give Akhil a huge abyss round of applause. Everybody's clapping at home, I promise, Akhil. So, as we dive into this topic, let's start where we always start with the Constitution and with the framing idea behind this conversation. I think due process seems like a very simple idea, but it gets lost a lot for people and people throw it around at each other. So I would really like to ask both of you, maybe David, we'll start with you first. Could you frame for all of our people online, what is due process, the simple idea behind it? And Akhil, maybe you can give us, where did the idea come from? Why did we put it into our Constitution and when did we do that? So a double header on that one.
Yeah, it's a great question to start. What is due process? And it's a concept that's surprisingly difficult to easily define, but I'll give it a shot. Basically, that there has to be a evidentiary threshold that has to be satisfied before the imposition of a state punishment. In other words, before the state is going to punish you, is going to deprive you of your liberty, deprive you of your rights, there is going to have to be a particular showing of evidence. There's going to have to be a particular process, and that it cannot be an arbitrary determination made by one person based solely on that person's individualized judgment and or prejudices. And the way to think about it is to think about due process as an evolutionary process, an evolutionary step away from absolute monarchy. So the American experiment, and I know that Professor Amar is going to get into this, but the American experiment is an evolutionary step away from the absolute monarchy that tended to dominate, for example, English life in the centuries before the American founding. And if you go back from Magna Carta all the way running to the English Bill of Rights, there is a steady pulling away of absolute authority from the king. And what's one of the things that the king used to do? The king used to dispense justice. So how are you going to pull some of that authority from the king's arbitrary determinations? Well, you're going to create legal processes. You're going to create rules of evidence. You're going to provide for things like juries that are going to be a part of the adjudication process. So when I think of due process, I think of those are the concrete elements that are put into the judicial system that guarantee that any given person is not going to be imprisoned or lose their liberty on the basis of the arbitrary conclusions of a single person or a group of persons. It is, what do you have to show? What do you have to demonstrate? What evidence can you bring to substantiate a claim? And that's the heart and the core of what due process means.
Thank you so much. Fantastic. And it is, as soon as you start to try to frame this around a simple system, it does get pretty complicated because we can't look at the law as this applies or this applies. It's really a web system of a legal system, of a justice system that applies, and how does it work through? Akhil, where this idea that taking it away from an individual person in charge to a system to ensure fairness, ensure that there is a process. From the city of the Phillies, we always like to trust the process, but we need to make sure that we don't.
It's not working out well for you now, Curry.
That will be the one sports joke you ever get from me in this entire program, non-sportsy. But don't worry, you have to have faith too, David. But Akhil, where do these ideas come from? How do they, as David said, evolve? And where do we see them in our established laws?
So great to be with you both. I think David got us off to a great start, as did you, Curry. In just a nutshell, fair procedures, legal procedures, due process, that's like procedure. It may vary depending on the context. Some people get more process than others because what's at stake may be a more serious imposition, more serious deprivation. So what exact process is due may vary. Those of you who are in high school, it might be one thing if we're talking about whether you're just going to have to stay after school because you were shooting spitballs, or whether you're going to be suspended and it's going to be put on your student transcript that gets sent off to college, whether you're going to get expelled. Depending on the severity of the imposition, you might get more procedure. You may not even necessarily get to a court yet, but there have to be maybe some kind of fair hearing where you get to make your explanation of what happened. So due will vary. What is due and under the circumstances? Process, fair procedures, where you get a chance to explain what you think happened, and people can present different pieces of evidence, and of law. It can't just kind of be made up. We have rules about this, ideally rules established in advance. So due process of law. Now, not everyone limits the phrase to that. Some people say, oh, the law has to be substantively fair. That's sometimes called substantive due process. Wow, there's a huge debate about that. Maybe we get into it, maybe we don't. Maybe we just bracket it. But you asked, where does it come from? Well, my friend David mentioned Magna Carta. It had a phrase that people couldn't be intruded upon without the law of the land. And that got translated in various ways and updated over the centuries. Magna Carta is from the 1200s, early 1200s, to sometimes it was law of the land, sometimes it was called due process of law. And Magna Carta, by the way, wasn't written in English. So a lot of people didn't even quite understand, ordinary people in England, what it quite meant. But that's a legal tradition, what's sometimes called a common law tradition, that eventually carries over to the American colonies. They believe that they are entitled to what they would have called it the rights of Englishmen. That's how they would have described it. And that tradition informs colonial Pennsylvania and colonial Massachusetts, colonial Virginia, and some of the other mainland colonies. And then at the time of the American Revolution, when we declare our independence, it informs, so it's part of the colonial experience, and then it's going to inform state constitutions in Pennsylvania and Massachusetts and Virginia and elsewhere, and eventually the federal Constitution. And when English people come over from England to America, they carry with them in their heads this idea that we are entitled to English rights. England has grand juries, we should have grand juries. England has criminal trial juries, we're entitled to that. England has civil juries, not in a criminal case, but if a person A sues person B, saying, you trespassed on my property, your tree fell down on my piece of land and destroyed a building on my side of the property line. So Americans believe, especially in juries for civil cases between two individuals, criminal cases, typically where the government is trying to impose a very serious imposition on an individual. Grand juries are another thing. Before you even are forced to stand trial criminally, often a jury has to sort of weigh in. Is there enough evidence to even justify holding you for trial? So these are some, but not all, of the mainstays, the central pillars of Anglo-American due process. Fair procedures, legal procedures. In our tradition, paradigmatically, grand juries, civil juries, criminal juries. And if you read the Declaration of Independence, it actually says the King and Parliament have deprived us in many cases of trial by jury, the inestimable privilege of trial by jury, and various English practices in the 1760s and 1770s actually were trying to evade jury trial through things called vice admiralty courts and all sorts of other things that I talk about in The Words That Made Us, this first book, where England was doing all sorts of things, depriving Americans of especially their cherished jury rights and other fair trial rights.
Thank you. That was so perfect. And I really appreciate it. There is a new rule from now until the end of next year that you have to at least once bring up the Declaration of Independence in every conversation.
Totally.
I knew it was going to come up easily today, but I just thank you for doing it without knowing. Gold star to you, Akhil. So for the 250th anniversary, we're kicking it off early. But I guess, and I have a million questions to kind of dive into it, but let's do a little bit more framing before we dive into parsing it out about today's society and where we see this. So, due process is to create a fair system. And the flip side of that coin is it's also to protect people against unfair individuals, unfair rulers in a way. How does the codifying it in the Fifth Amendment and then again codify it in the 14th Amendment, why is that needed? If it is an evolution of rights to move away from that monarchy, to state the claim in the Declaration, as we codify it, where are we seeing the systems work effectively and not work effectively over American history? And David, Akhil, jump in either one.
Yeah, I would start with why did we codify the Fifth Amendment? It's a great question. It goes down to one of the earliest arguments in our new constitutional republic, which was between the Federalists and the Anti-Federalists, two factions, over whether we needed a Bill of Rights. It's a complicated debate. I don't want to oversimplify it, but at the risk of oversimplifying it, let me just say the Federalists would have said the original Constitution, without the Bill of Rights, limited the power of government so much that you didn't need to spell out these rights. The original Constitution essentially withheld from the government much of the power to violate these rights. And besides, if we list all the rights, are we going to list them all? We can't list them all. So the very act of creating a list would, by necessity, exclude certain kinds of liberties. And the Anti-Federalists, who team Anti-Federalists here on this argument, said, whoa, you're way too trusting of the government. And by the way, have you read the Constitution you just ratified? It has some really big, broad grants of power to it. In fact, some of the grants of power are so big and broad that Anti-Federalists were raising concerns that the president's going to be too powerful. The president's going to be like a monarch. And so they said, we need to spell this out. We need to absolutely spell this out. And so the Anti-Federalists won the argument, and that's how we get the Bill of Rights. They spell out these liberties. And one of them in the Fifth Amendment is this guarantee of due process. And I would call that evolutionary, not revolutionary. It was evolutionary because, yeah, it's calling back to, as Professor Amar said, the colonist conception. We had rights as Englishmen, right? And the crown was denying these rights as Englishmen. And then if we're going to create a new nation, we got to be very clear about what our rights are. We don't want to go through what we just went through again. And so they create this list, but here was the kind of weird thing about it, from our modernized, the weird thing about it. The original Fifth Amendment only restricted the federal government. And you might say, why would you put only in front of the federal government? The federal government's big and powerful, and it needs a lot of restrictions. Back then, the federal government was small and tiny and had very little power or authority, and very few criminal laws were attached to the federal government at that time. And so in that standpoint, yes, the federal government was being restricted, but the state governments had a lot of room to run and to be unfair and to violate rights. Now, a lot of state constitutions included, due process protections and things like that. But especially if you're talking about the South, where you had slavery, there's no due process protections for enslaved people. And so you had, in conception, this beautiful statement of human dignity, which was the Fifth Amendment. A wonderful statement. To this day, the Bill of Rights are one of the best articulations of fundamental human rights that have ever been put pen to paper. But if you go back to the late 18th century, it had very little effect on people's lives because it just restricted the federal government. And that's how you have this America of very systemic injustice. And in multiple states throughout the early American period, and most notably slavery. Slavery is incompatible with any real conception of due process. And so that's why we were going to ultimately need what became known as the Second Founding during and after the Civil War, which expanded the reach of due process to all Americans, which was, it was such a large expansion that I would call that the truly revolutionary expansion, whereas the Fifth Amendment was evolutionary. I look at the 14th Amendment as revolutionary, because that's what took this grand statement of principles that was in the Declaration of Independence and the grand statement of legal reality that was in the Bill of Rights, but very limited in its application, and then brought it to all of us through the 14th Amendment. To me, that was the real revolutionary act.
Oh, and that is so perfectly teed up for Akhil to jump in on the 14th Amendment. I'm going to stretch that even so beautifully done, David. Akhil, to you.
So today is December 10th. 2 days ago, on December 8th, I was actually in Washington, D.C. I always try to get out of the city as fast as I can because it's a dangerous place for anyone who's really, entranced by, power and awe and in awe of this very powerful place where powerful people do all sorts of things. So I got out of town fast. But on December 8th, I was at George Mason University, the Antonin Scalia Law School, to commemorate the 300th anniversary of the birth of a man named George Mason, for whom George Mason University is named. He was born on December 11th, 1725, so 300 years ago tomorrow, and he was the author of a Virginia Declaration of Rights and he drafted it actually even before the Declaration of Independence in May of 1776. In his version, it had a very famous phrase, all men are born equally free. That got changed. And Thomas Jefferson is borrowing from him. They're both borrowing from John Locke. And they changed it in Virginia precisely because they didn't like some of the anti-slavery implications of a sweeping pronouncement that everyone's born equal. Because what about slaves? So they did modify it in Virginia. But my friend David is right that we have these important state constitutions. Even before the Declaration of Independence, there's actually a written Virginia Constitution, state constitution, with a Declaration of Rights. And Mason is important in that project. So is James Madison, who broadens Mason's articulation of religious freedom, which we won't talk about in great detail today, but is a theme of David's work over many years. So we have states. And they have state constitutions and state declarations of independence. The states aren't strong enough to protect us against thugs from Europe, monarchs who covet American land. So there's going to be another conclave in what we call Independence Hall, the State House, just steps from where you are, the Pennsylvania State House. So the Declaration of Independence originates there in July 1776, but 11 years later, people meet in that same place to draft a constitution for the continent that will be stronger for national security. Oh, and who's there? Oh, it's our pal George Mason. And he's on board he's from Virginia, much of what's going on, but at the very end, he refuses to sign his name to the thing because most of all, there's no Bill of Rights. There's no Declaration of Rights. And he says, I can do it in an afternoon. He says kind of late, let's add it. State constitutions have it. Let's add it to the federal government's constitution. And the other people, truthfully, you won't see this on the page, but if you actually put yourself in the room, they're tired. They're hot. It's humid in Philadelphia. I know you're shocked that it can be hot and humid in Philadelphia, and they want to go home. And he says he can do it in an afternoon. He did it in Virginia, and they're thinking, this guy's a pain in the butt. It's going to be 2 weeks, if we try to write everything up. And so they don't take his advice, and he actually opposes the Constitution during the ratification, mainly because it lacks a Bill of Rights, a Declaration of Rights. He also thinks Congress is too small to be trustworthy. And I'm glad he lost, because if he had won, then there would be no Constitution at all. And where would we be? But what happened is we adopted the Constitution, re-ratified it, and then, those are the Federalists, we reached out and added a Bill of Rights to accommodate people like George Mason. So, wow. Americans contested each other. Half were on one side, half on the other. The Constitution passes by this much. But here's what's amazing. The losers acquiesced. They didn't try to stage an insurrection, even though they didn't lose by a lot. And then the winners listened to the losers and said, you guys wanted a Bill of Rights. We needed to ratify the thing first, but you had some good ideas. Let's work together. And so it was George Mason and James Madison and George Washington who together and with others, the opposing sides come together to craft what we call the Bill of Rights, and the Fifth Amendment is a big part of it, but there are others, first, second, and so on. And then finally, my friend David is just right. That didn't protect against states. It was anti-federalist in origin. The anti-federalists are worried about the new federal government. States have been around for a long time. There were colonies before there were states. So there was Virginia for 200 years. There was Massachusetts for 200 years. In 1787, it goes back a couple hundred years, okay? Massachusetts and Virginia are formed in the 1620s, 250 years. 150 years between 1620s and 1787 or something. They've been around a long time. But this new federal government, who knows what it could do? It's going to have armies. It's going to be able to put people to death for treason. Oh, we want to have rights against it, fair procedures and other rights, but it doesn't apply against the state governments. My friend David is just right. 10th Amendment is about states' rights. First Amendment, what does it say? It doesn't say freedom of speech abstract. It says Congress shall make no law abridging freedom of speech. It actually says Congress can't have a national established church. Oh, but states have established churches. Half of them do. And states later misbehave. Slavery, paradigmatically, Southern states misbehaving. So yes, there is a recognition you need a second founding after the Civil War, a new Bill of Rights, a second Bill of Rights. And now these amendments come to apply against the states as well as the federal government. That's called incorporation of the Bill of Rights against states. I wrote a book on it. Here's the title of the book, The Bill of Rights, Creation and Reconstruction. And part one is creation. It's what the Bill of Rights originally meant as against only the federal government. And then, in effect, the second Bill of Rights, the Reconstruction, when it gets applied against the states. If you're Christian, it's a little bit like Old Testament and New Testament. Okay, you've got one set of scriptures, so to speak, and then you come along and you kind of modify them with a different text, and you're reinterpreting the earlier text in light of the later text. It's very interesting. Again, lawyers call that incorporation. So Curry, you're right. There actually isn't one due process clause. There are actually two. One's in the Fifth Amendment. It applies against the federal government. And it's from the 1790s. Another one is actually in the 14th Amendment. It's from the 1860s. And it says, no state shall deprive anyone of life, liberty, or property without fair procedures, without due process. So, audience members, in like half an hour, we've gone from 1200 and Magna Carta, to, half a millennium of British history. We've crossed the Atlantic. We've gone 3,000 miles. We've done the colonies and the states and the original Constitution. And now we're all the way up to Mr. Lincoln's generation and the Civil War.
I love a good timeline. That's my brain wraps everything around a timeline. So Akhil, thank you so much. And we're going to clip all of this and then put a timeline visually on it. I do want to go back to Mason just for 1 second, because what you said there, I think is so important as we go into this 250th anniversary of the Declaration of the Constitution. And I do think there needs to be a separate club of people who love Mason and talk about him more because he does so much. We saved Gouverneur
And 2
Morris.
days ago, I said nicer things about him today than I did 2 days ago, because these guys at George Mason, but so great. I said, actually, Mason wasn't as great on slavery as you'd like him to be. He doesn't free his slaves. I'm very glad that David has teed up the slavery issue because it's huge in American history. And since yours is a Quaker institution, the Quakers have concerns about, savage punishment. they also, for some of the same reasons, have concerns about slavery. They are among the most important and the earliest abolitionists in the history of the world. And Philadelphia is their city. And way before the Brits get rid of slavery in the West Indies in the 1830s, Pennsylvania is abolishing slavery itself. Based on its 1776 Constitution that says all men are born equally free and independent. And so the world's first abolition project begins in Philadelphia in 1775, 1776. That is the story I tell in my new book, Born Equal. And it's connected because savage punishments are cruel, so that you need fair procedures to spare innocent people from that. Slavery is cruel. So you're seeing how some of these deep ideas, fair procedures, but also ultimately human liberty and equality, these things are connected. And the Quakers are hugely important in this story. Philadelphia is hugely important in this story.
And
You know,
see, and that, okay,
as long
you
as
go
we're
right
giving
ahead.
shout out, just a
I'll
super
take
quick
all the
thing is
Philly shout outs.
as long as we're giving shout outs to Pennsylvania and the Quakers of Pennsylvania, it's also the Quakers in Pennsylvania. I recommend a great book called The Crucible of War about the French and Indian War, which is known in the 7 Years' War in Europe. This is the war preceding the Revolution. It was fascinating to read how the Quakers were early leaders in American public life in treating Native Americans with dignity. And that one of the really interesting dynamics in early colonial life was this clash between the Quaker virtue and the Quaker love for, the sort of the Quaker universal regard for human dignity versus sadly, what was the reality in a lot of the colonies in which human dignity, the Native Americans were not always treated with dignity and respect. And so another shout out to Pennsylvania.
So there's so many references here that I love, and I promise I'll get this to the next question because I think it's been teased out a few times, and it's a pretty simple question. But go back to Mason for a second. There is a great letter that he writes to George Washington during the big debates around the ratification of the Constitution. And I'm going to paraphrase it. I think Gunston Hall has it in their collection. And he says to Washington, "I don't do this for any other reason but that I am a patriot. I do it for love of country." But Akhil, you pointed out something really important there. It is not just the people that stand up and say we need to do better. It is also the people that they're saying that to, opening them in to say, how can we learn to do better together? So that's a really important side of it. We tend to talk about dissent in America as those who dissent, but when it's done in a way that moves us forward, it is also a reception. Quakers in Philadelphia, one of the first written documents is again a Quaker letter in 1695 stating the public reprimand for enslavement. And that's at the Historical Society of Pennsylvania, which is right here in Philadelphia. And I believe they have it online as well. And that idea of inner light is at the base of this, that for them, for the Quakers, they believed that God was in everyone. So as long as you could focus on that inner light and get back to that inner light, that everybody was good. But it also said, can the government do this to somebody? Because then they're doing it to God, which really kind of does pressure us around these concepts of walking away from traditional monarchs as well. We do have to just rationalize that, all these positive things, just like Mason, the Quakers also came up with the idea of solitary confinement, which is what Eastern State made it the first penitentiary in the world. It was large scale solitary confinement. They tested it out right across from Independence Hall at the Walnut Street Jail. And they were well aware that it was creating extreme mental health concerns within the first 2 weeks. So the thing that we go back to is always a system of law, and a system of due process to ensure, because sometimes people get really excited about the good idea they have and won't listen to when it's not working. So I go back to this question and say, as we think of these systems that are written to ensure dignity, that are written to ensure fairness, that are questioned and evolving over time, and we talk about due process. And you, David, you brought up the Native Americans, and there's another really good
Mhm.
book I'm reading right now called The Cover of Night, which is an
Mhm.
excellent book on Native Americans and due process. But the question is, who does it apply to? So
Yeah.
when we look at all these pieces over time, who does due process apply to? Does it apply to me because I am a human, or does it apply only under constitutional questions around the citizen? So unpack that really big, simple question.
Yeah. It's a great question. And the answer is, as a practical matter, it's been applying to an ever expanding group of people because of because of the universal declarations that exist at the founding of the Republic. So we have to, as we've now entered into a new half hour, which we've not yet really mentioned the Declaration of Independence yet. So let's do that. So if you're looking at, I think, let me call back to some culture war disputes of the past. So a lot of people might remember the 1619 Project. This was something that came out of the New York Times that was, okay, we really need to think more about what it meant when the first slaves arrived on our shores in 1619 and what that tells us about our Constitution, what that tells us about our history, our nature. And a lot of conservatives got upset at the 1619 Project because they thought it was excessively negative. And so they created a 1776 project focusing on the good parts of the American story, particularly the opening of, the grand opening of the Declaration, where all men are created equal, endowed by our Creator with certain unalienable rights. And the way I look at it is American history is really the history of 1776 versus 1619. In other words, you have this kind of human nature that exists that's been found throughout human history where societies tend to devolve into the strong dominate the weak, that the strong exploit the weak. And that a much of the revolution and transformation of human societies has been in trying to find virtues and philosophies, theologies that elevate the human person, that provide and bestow dignity upon the human person. And so, if you look at it this way, slavery coming to America was a sign that this new civilization that Europeans were carving out on the eastern seaboard was going to be very much like the old civilization that they left. That in fact they were just bringing Europe to America, right? And so that was the negative story. And but then there's another story that a lot of the people who came to America from Europe came with a specific idea of human dignity and liberty and freedom, and so you had this contest from the very beginning in this new world. It was not a new world to the Native Americans, but in what we're often called a new world. What is the nature of it? And so you have this contest right there, the darkness of our human nature and the better angels of our nature. And the darkness is manifested in slavery, treatment of Native Americans. The better aspect is embodied in the Bill of Rights, in the Declaration of Independence. And it is very, very telling that every marginalized community that has really achieved much greater liberty and much greater dignity in this country has done so by appealing to these founding principles, not by rejecting them, but by holding them up and saying, this is what you promised all of us, deliver. Martin Luther King called this the promissory note. It's a promissory note. And so that's one thing that I think is so powerful about the American experiment. It's not that we people in America are a better class of people. We're all made from the same human clay. But it is absolutely the case that at very specific periods in history, whether it was the founding, the second founding after the Civil War, at very specific periods of history, those better angels of our nature asserted themselves in such a decisive way that for decades and generations to come, then future generations could appeal back to those principles and say, apply them to me, apply them to me. And I think the story of due process is that story in a nutshell. Because if you want to go back and you want to look at some of the differences between criminal procedures in the US in 1940 versus 2025, it's massively different. It's massively, and it didn't all change in one giant big leap. It changed incrementally over time. And we still fight about it today. What are What's due process in a death penalty case versus due process in a student discipline case versus due process in a criminal, in say a bank robbery case? These are the questions we still wrestle with. But I will tell you, if you have sort of pessimistic feelings about America, which many people do, just to have some historical perspective, where we are now versus where we were then, just in the region of due process. Wow. Wow, we've come a long way in 250 years.
Thank you for
So
that,
to
Akhil.
just briefly to put the point textually, I'm reading my pocket constitution here, and I do commend to all of you the National Constitution Center's website on the interactive Constitution, where you can read the Constitution online and also read commentary, academic scholarly commentary about each clause of the Constitution. But here's the Fifth Amendment. No person shall be ... deprived of life, liberty, or property without due process of law. So that seems to be pretty broad. Now, and that's it's proposed in 1789, September. It's ratified in early December, 1791. And I assume that's kind of why we're meeting in early December, kind of commemorating the ratification of the Bill of Rights. And it says no person, but an infamous Supreme Court case called Dred Scott, 1857, said, blacks, even if they're free, even if they're not slaves, but free blacks can never be citizens. That's one thing Dred Scott says. Never. If you're descended from the slave race, you can never be a citizen. Now, Dred Scott made that up, the court majority, but that's what they said. And they also said that only citizens have constitutional rights. So and yet another thing they said was Congress can't prohibit slavery in the territories because that's depriving people of their property, unfairly, reading the due process clause in a preposterous way. So Dred Scott said three things. Congress can't prohibit slavery in the territories because that's taking away property unfairly. And Lincoln and others say, why, we're fair procedures. We have judges and juries and we have a law. And the law is if you don't want to lose your slaves, don't bring them to the territories. Just like, if a state says, we're dry, don't bring your alcohol here. If you do, we'll take your alcohol away. Okay, maybe you can have pot in Colorado, but don't bring it to Wyoming. If you do, we're going to take it away. So there was nothing wrong with saying no slavery in the territories. But Dred Scott said, that's a violation of substantive due process. So, but Dred Scott, this is the Dred Scott opinion, Roger Taney, 1857, it said two other things. One, blacks can never be citizens. Even if free, they can never be citizens. And two, only citizens have constitutional rights. Now, the framers of the 14th Amendment didn't believe any of that. They believed in not only prohibiting slavery in the territories, but prohibiting slavery everywhere. That's the 13th Amendment. And they believe that everyone, black or white, is born an equal citizen. That's the first sentence of the 14th Amendment. They're all born not just equally free, but equally citizens. And that's the birthright citizenship debate. And in the Interactive Constitution, I wrote the little essay about that sentence, so you might want to read it, audience members. And I'm hoping, actually, David, to pitch something to your newspaper, the New York Times, an op-ed on just this topic. So keep your fingers crossed for me. But the third thing that the framers of the 14th Amendment did, prohibit slavery everywhere, not just in the free states, say everyone is born an equal citizen, black or white, male or female, Jew or Gentile. But finally, they reiterated that persons have rights above and beyond the rights of citizens. So they say, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. And then they say, nor shall any state deprive any person of life, liberty, or property without due process. So it's really clear by the juxtaposition of these two clauses that person means person. You don't have to be a citizen, just any person. A person's a person, no matter how small. That's from Dr. Seuss. Horton Hears a Who. So to answer to your question is, in America, persons have rights to fair procedures, not just citizens. So if the government plucks someone up and tries to throw them in prison and prosecute them for a crime, they're going to get fair procedures here. They're going to get a grand jury if the federal government tries to do it, and a trial jury and proof beyond reasonable doubt and other fair procedures. And that's going to apply to states as well as the federal government. And 95% of criminal prosecutions today, maybe 98%, occur actually in the state governmental system, not in the federal system. So David was right earlier when he said applying all these against states is a very big deal in America.
Fantastic. That was perfect. And it really does bring me to the last question. And then I'm going to ask a couple from the group because I know some of our students have to jump off at the 12:50 to get to their next class. But we talk so much about the right to a trial, the right to a jury. I do really want to talk a little bit about plea bargaining, but maybe that'll be the next program we do this on.
Lots to
But
say there.
I know. There's so much we can go on this. I mean, but I guess the question is, so what are your due process rights once you're incarcerated? We talk so much about the Bill of Rights before you have interaction or when you have that touch point with the justice system, but we tend to forget to talk about that, what happens and what rights apply to you while you're incarcerated. We have these protected spaces that the judges kind of stay away from in schools, K through 12 schools and in incarcerated settings. But what kind of due process rights do you have while you're incarcerated?
Well, let me just remind folks that some people are incarcerated even before they've been convicted. It's called pretrial detention. And that's why the bail provisions of the Constitution are so important, that before you actually are incarcerated pre-trial, you ordinarily should be able to post bail. There are exceptions and limitations. At trial itself, and some people are incarcerated during their trial, but let's just remember, it's not just that you get, for example, a grand jury before you have to stand trial and a trial jury before you're convicted, but you're going to get a public trial and a speedy trial. And there's going to be proof beyond reasonable doubt, even though it doesn't say so explicitly, because they're implicit rights as well as explicit rights. You're going to have a right of counsel, government-appointed counsel if you're indigent. You're going to have a right to cross-examine the witnesses against you, to compel the production of witnesses in your favor, to be able to subpoena folks and all the rest. So a whole bunch of fair trial rights are components of due process. We talked about George Mason, and we talked about writing rights down, textualizing them in declarations. One of the arguments on this side is, gee, we can't textualize everything, because if we say, 19 things, maybe, there are actually a gazillion rights, and we won't remember we won't even be able to list them all. Very famously, David, the conversation was, don't you have a right to wear a hat? I'm saying that to you because you're wearing a hat. And they actually said, people have a right to wear a hat. And by the way, William Penn in England was attacked by a judge because he didn't doff his hat. Actually, he had a big Quaker, wide-brimmed hat. They weren't making up that right to wear a hat, meme. So above and beyond the specific rights, there are implicit rights, the enumerated rights, there are implicit rights as well. But you were asking maybe about post-conviction incarceration.
Yes.
But I just want to remind people that even before conviction, there are some people who are being detained, held.
It's hugely important. So just last year, 38,000 people in Pennsylvania lost access to the ballot because they were detained but still had the right to the ballot. And it's a huge conversation happening across the states, especially as we go through elections. So thank you so much for bringing it up. David, do you want to jump into this due process once you're convicted?
Yeah, there are a host, but once you're convicted, you don't stop being a human being possessing constitutional rights, that you're deprived of a great deal of your liberty, no question about it. You're not deprived of all of your liberty interests by any means. So you continue to have your rights of appeal. I mean, this is one thing that's wonderful about our system, is that you have rights of appeal up through to, your appeal to the Supreme Court of your state or to the Supreme Court of the United States. It doesn't guarantee that the Supreme Courts of the state or the US will take your case, but you can go all the way up. You have a first appeal as of right. You're going to have a court of appeals review your conviction. Also, you have habeas rights in many circumstances where you're going to be able to sort of go straight into federal court to challenge the conditions of your challenge your confinement. You have a lot of rights to be treated. Now, this isn't Fifth Amendment, but we're getting into prohibition against cruel and unusual punishment. The state cannot decide that prison becomes a hellscape. Now, prison can be tough. It can be tough, but it can't cross this threshold of cruel and unusual punishment. And so you are still a rights possessing person when you're incarcerated. Why? Because you're still a person. And within our constitutional framework, people, not just citizens, but people are entitled to be treated with dignity and respect. And that dignity and respect is codified in very specific ways that stick with you, even if you have been convicted and even if you've been convicted of the most heinous crimes. There is an irreducible level of human dignity that attaches to every person, incarcerated or not. And I think that that's something that sadly a lot of people forget. They'll hear about terrible conditions in prison and they'll say, well, they're convicts, as if that suddenly makes them less than fully human. And that's just not the case at all. And our law recognizes that and protects that, even to the point of, you're going to still enjoy some religious liberty protections in prison. That's not particularly due process, but it's just a demonstration that your humanity doesn't end with the moment a guilty verdict attaches to you.
And we just did that program last week with Kermit Roosevelt and E.B. Eisen from the Brennan Center. So we'll send that out to everybody as well. And on a fun side note, this penitentiary was the first synagogue on any prison site in America. So we have it was one of the first documented cases of people gathering at Eastern State was a September Jewish holiday. And then they built the official synagogue in the 1920s. So lots of fascinating facts. And Akhil, your last meme was really impressive that you developed the memes through American history. That might be our next game show. Two questions they're really wrapped around this big idea. One question is the question from Ronnie is, can the president pardon somebody that has a state conviction? And if they cannot, does that limit their ability to really have access to due process? We'll start with that question.
Well, the federal constitution regulates the federal government, the federal punishment system. So presidents can pardon for federal crimes and can issue pardons even before there's been a trial or conviction. Take Pennsylvania. George Washington very famously pardons thousands of rebels in Western Pennsylvania. It's called the Whiskey Rebellion. He says, you've done things that may be even technically treasonous, but if you lay down your arms, if you just walk away, if you dissolve this mob that you've assembled, I'll forget it and forgive, and you can go back to your homes. And that was a mass pardon in Pennsylvania, but for federal offenses, because the federal constitution, to repeat, regulates the federal government and federal punishments. Now, if you're convicted of a state crime, or even at risk of being convicted of a state crime, your recourse and remedies would be through your state system, typically through your state governor. In some states also, there are pardon boards and parole boards and other boards, but we've got different systems of government in America. A state government regulated by state constitutions, and state pardons would be a part of that. And then the federal, which has a different set of punishments and procedures and indeed pardons.
Fantastic. Now, our next question, which I figured it would come from this one, so thank you for asking it. Jason, where does this fall on people being deported that have committed crimes? This is, David, I believe this is really your piece in the New York Times in April. It was excellent, by the way, and I will share it with everybody. And I'm forgetting the really clever name, but it was basically "Don't bulk at due process." You'll share the exact name. And could you guys share Where does that fall? Is that not allowing due process?
Oh, go ahead, Professor.
Oh, well, so uh, you're getting fair procedures. Now, what procedures you're getting may depend. If you're, for example, let's say you commit a crime. Well, you're guilty. The moment you do it, you haven't adjudicated that you're guilty, but you did it. And we're going to have fair procedures. And if you did it, then it may be proper for you to be convicted. And then we have to figure out what's a fair punishment. So if you're here and you don't have a legal entitlement to be here, we can have fair procedures and deport you, whether you're criminal or not. My parents, when I'm born here, are not U.S. citizens. They were here legally. They had been invited to America as young doctors. They came, they had a visa, but let's imagine they had overstayed. And because of that, I'm an American citizen when I'm born in Ann Arbor, and it doesn't matter whether my parents are or not, because the Constitution says people who are born under the flag are, as a general proposition, American citizens. But if my parents had somehow overstayed their visa, they were here illegally, there could be procedures, due process, and yes, they could have been sent back. Now, and I, as a kid, as a practical matter, would have had to go back with them, or they would have had to find some family or relatives for me to stay with. I'd still be an American citizen, and when I'm 18, I can come back on my own. But of course, we can deport people who don't have a legal right to be here, but we have to have fair procedures, and what process is due will depend on circumstances. I'll give you 3 examples. One, you've been here for 40 years. You're not a citizen, but you're a green card holder, a permanent resident alien. You've married an American citizen. You have many children, maybe grandchildren who are natural born American citizens. You go off to visit a dying relative or something to the old country. And then you try to come back and they won't let you back in, or they just try to toss you out. Wow, you're going to get the Cadillac of fair procedures because your connections with the United States are so great. It's like being expelled from school as opposed to really having to stay, after in detention because you were shooting spitballs or something. So you're going to get the Cadillac of fair procedures if you're a permanent resident alien who's been here a long time and they're trying to kick you out or not let you back in. At the other, in the middle, if you're just here on a student visa or something and it's expired, you're going to get some procedures perhaps, but maybe much less. At the other extreme, you haven't even been here yet. You're in India, you want to get a visitor's visa to visit your relatives or something like that. Oh, you're not going to get very much process at the U.S. Embassy in New Delhi. So what process, because there's not very much of a deprivation yet, because you haven't been in America yet, and you're not an American, and that's not punishment to say people who aren't Americans and who haven't been to America don't get to come here. Maybe that's a deprivation, but it's so infinitesimal given your baseline rights, you're going to get much less procedure. What process is due? What are fair procedures will depend on the circumstances.
Yeah, and I would add to that, that gave me a chance to pull up my piece because there was an analogy I used in there that in World War II, we had a situation where Nazi saboteurs arrived on American shores. This was in the middle of a declared war with the entire existence of the American Republic at stake, Western civilization at stake. And we granted these suspected saboteurs due process through a military commission, not a normal civil trial, but through a military commission. There was due process for Nazi saboteurs in World War II. But we recently had a situation where a bunch of suspected members of a gang were transported to a El Salvadoran prison with no process at all. So they were treated worse than suspected Nazi saboteurs in the middle of a declared war. And when this came out into the public, a lot of people were saying, well, I don't think gang members should get due process. I don't think that illegal immigrants should get due process. And the first question you should ask is, how do you know they're gang members or illegal immigrants without some kind of process? You don't just magically know. You don't look at a human being and say, oh, gang member, no matter what kind of tattoos they have. You don't look at somebody and say, oh, absolutely, you're an illegal immigrant, off out of the country with you. For us to even know who people are requires some kind of process. And so it's very interesting to me. And this goes to the importance of civic education, like we're doing right now. A president saying they're a gang member is not a process. A president saying they're a gang member after a process is adjudicated that they are, that's more acceptable. Okay. And so Professor Amar is exactly right. Not every claim of liberty is entitled to the same degree of process. Think of it like this: the more severe the deprivation of liberty, the greater the process that you're entitled to. The less severe the deprivation, the less process. So somebody who's facing the death penalty, for example, has access to a lot more process than a person who is appealing, say, a conviction for writing bad checks. And a person who has got a conviction for writing bad checks is getting more process than a person who's being thrown out of a public high school. Or, so you just, however, whatever the severity of the loss of liberty, the more severe the loss of liberty, the greater the process you're entitled to.
And
This is, oh, Dad.
I know we're getting very close to the end, but the Nazi saboteurs got a lot of process because in the end they were put to death. So you're going to get a ton of process. And here I'm going to actually sound maybe, more conservative than David, even though perhaps in American politics, that's not always the case on other issues. Where someone makes no claim of American citizenship, they can see that they're not an American citizen. They may deny that they're a gang member or something like that. They're going to get less process, and it's going to be less of a punishment to say, while we're litigating other things, you should stay outside the United States because you don't even claim to be a U.S. citizen in a way that others do. Now, if we're going to try to punish you in some way or send you to a hellhole in some way, that's going to be different than just, why didn't you wait in your home country while we adjudicate these things? So these are complicated questions. Yeah, when you look at someone, you don't know whether they're even a citizen or not. But if they admit, hey, I'm not a citizen, but I want to stay here because I think I have a good asylum claim, because I'm going to be treated very badly if I have to go back to my home country. You're going to get less if America just says, stay where you are, or we're going to send you back where you came from while we're adjudicating this. The Nazi saboteurs were put to death. They got the Cadillac of procedure, although not quite. It was military. It's called a case called Ex Parte Quirin. But final point, just because David mentioned someone epic, Martin Luther King. And let's remember that even when Martin Luther King was in jail, he had not just religious rights, and he was, a preacher, was the Reverend Dr. Martin Luther King. He had other First Amendment rights. One of his most compelling contributions to the American tradition is a famous letter from a Birmingham jail. So even when they put you in a penitentiary, something like that, wow, you do still have your human dignity and lots of rights. But even though there can be very severe deprivations of liberty, I don't mean to deny that.
This was unbelievably powerful. We started this conversation with the idea of, you hear this word due process being tossed around a lot, and it seems like it should be pretty easy and clear. It's not. That's okay. Our Constitution is complicated. Our system is massive. But I think what is so unbelievably powerful is that we have to lean into understanding that complicated system. We have to lean into understanding that if we have a value of fairness and justice to establish justice, that means effort needs to go into ensuring that it happens. As you guys were speaking, I always come up with this brain visual that it's almost a lot of different levers. When we think about a system and we start to apply it, directly and proportional. If the loss of liberty is higher, then the process is going to be higher. But there's other pieces to that too. Were you here? Were you not here? Can you go back home? This is really powerful stuff. And it makes these conversations complicated but necessary. So thank you both so much. It was such a great conversation. We're actually doing a program in January on that letter from Birmingham jail, we had two different newspapers in the 150 years that Eastern State was open that were completely run by incarcerated people here. The First Amendment was not denied in some ways with those newspapers, but it's such a powerful dialogue to have. How do we ensure that our rights are being established? How do we check the system to make sure that we are holding up the values that we believe as people in this country? So thank you both so much. Wonderful to have you both. Everybody will do a roundup. And as you exit, give them a big round of applause. So thank you. Have a great day, everyone.
Thank
Yay, I
you.
know. I need like an
Thanks.
audible cheer, like an old-timey show.
David, say hi to Sarah for me.
I will. It's so good to see you, Professor. Always great to see you. And yeah, are you going to be at the NCC event in February?
Don't know, but if
Okay.
invited, I'll come.
Okay. Okay.
Well,
Wonderful.
I hope to see you. If you're both in Philly, you know you have to come visit me.
It's true. It's true.
Okay, have a good one. Thank you both so much. Thank you, everyone.
Alrighty.